Hi, I'm attorney Scott Poisson, a personal injury lawyer licensed in Nevada, Arizona, New Mexico, and Florida. My goal with these videos is to educate you about personal injury before you actually need a lawyer, and hopefully you never will. So let's get into it. Emily finishes work and pulls into a grocery store to pick up some items. It could be Walmart, Smith's, Vaughn's, or any other similar big box store. She gets a cart. Emily pushes her cart down the aisle when suddenly her right foot slips from underneath her. Both of her feet are now off the ground until she crashes on her back against the hard tile floor. What should Emily do? Well, the first thing she needs to do is take care of herself. She needs to make sure that she does not require urgent, immediate medical attention. For example, if she hit her head or if it appears she may have broken a bone or can't walk. Next, after she gathers her senses, she needs to look around and figure out what caused her to slip. It is always ideal if she can determine the source of the spill or leak. If possible, it would be best to take pictures and or video of the scene. If she can't do it, maybe there's someone at the scene that can take pictures for her. Emily should look around and see if there are any witnesses to her fall or who saw the dangerous condition. If so, she should get their names, addresses, and phone numbers. This is important because the store will certainly not gather evidence that is helpful for Emily. Similarly, if there are any employees that are in the area that may have seen what happened, she should try to get their names. Then she needs to document what happened. This means she needs to report it to the store. This is so important. I cannot stress this enough. If Emily leaves the store without completing a report, it is as if the incident never happened. It may severely damage her claim if she leaves without reporting. She needs to find a manager or some other employee and explain what happened. Also, make sure that she gets the name of the employee who helps complete the report. She needs to fill out the report and describe what happened. If Emily has any pains, no matter how minor, she needs to put them in the report. She needs to state anything that hurts. If she fails to do so, the store will later try to argue that she was not hurt. Along those lines, if she has any bruises, cuts, or any other evidence of trauma, she should take pictures. Emily should ask for a copy of the report. If the store will not give a copy, Emily should take out her phone and take a picture of the report. If Emily has any pains, ideally she should immediately go to an emergency room or urgent care center to document her physical pains. I know that is not always possible. If not possible, then she should go as soon as possible. The following day or two to the emergency room, urgent care center, primary care doctor, or some other healthcare provider. This is so important. Document pains and injuries with a healthcare provider as soon as possible. It is a good idea to do this to make sure that there is not an underlying serious injury that you're not aware of. And from a case standpoint, the earlier your pains and injuries are documented, the better for proving that the injuries came from the slip and fall. Emily also needs to preserve the shoes that she was wearing. She should put them in a bag, not wear them, and keep them in a safe place. They are evidence, and if there's a lawsuit later on, the store can ask to inspect them. If her clothes got grease or oil or are stained, she should also preserve her clothes as evidence. Finally, Emily should contact an attorney who has a lot of experience handling slip and fall cases. An experienced lawyer will know the correct letter that needs to be sent to the store requesting that video surveillance and any other evidence be preserved. If too much time passes, if there is video, it will be taped over and lost for good. To recap, if you slip and fall in a grocery store or big box store, try to do the following. Number one, your health is most important. Gather your senses and make sure that you do not have an urgent injury that requires emergency medical treatment. Determine what caused you to slip. If possible, try to determine the source of the spill or the leak. Take pictures of the area. Get the contact information for any witnesses, whether store employees or customers. Complete an incident report. Document your pains and injuries with a medical professional as soon as possible. And contact an experienced slip and fall lawyer as soon as possible. Now that you know what to do if you slip and fall in a grocery store, let's dive into slip and fall law. The biggest misconception that I hear about any area of personal injury is in regards to slip and fall. And I would have the exact same misconception as well if I was not a slip and fall lawyer. So here's the misconception. Almost everyone thinks that if someone slips on a wet floor in a store and they are injured, that the store automatically loses and must pay them damages. Nothing could be further from the truth. Let me say that again. People assume that if they slip and fall on a wet floor in a store, that the store is automatically responsible for their injuries. It's completely logical. However, it's wrong. In reality, the law says that the injured person has the burden of proving that either the store created the dangerous condition, knew about the danger before the fall, or, quote, should have known about the danger before the fall. What does all that legal mumbo jumbo mean? Simply put, it means that the store must have been negligent in order for it to be held responsible. I will now go into more detail regarding the ways to prove that a grocery or big box store could be held responsible for a slip and fall injury. Number one, the store created the dangerous condition. We have had cases where we have shown that an employee knocked something over, causing the hazard on the floor. We have had cases where employees accidentally punctured plastic bottles while stocking, causing a leak from the shelves. We've had cases where a store failed to properly inspect and maintain refrigerators, leading to leaks or a buildup of condensation on the floor. In one case, we were able to show that an employee was pushing a cart with a leaking milk jug to the stocking area, and it was dripping throughout the store. In that case, our client unfortunately slipped and ended up needing spinal surgery. Number two, the store had actual knowledge of the dangerous condition. This often occurs where there is a spill and an employee discovers the spill before someone is hurt. However, the employee leaves the area to get a mop and bucket without sufficiently barricading the spill in the interim. An employee should never leave a spill alone. Rather than leaving to get a mop, the employee should wait for someone else so that there's a person to guard the spill. In the past, we have been able to gather evidence where an employee was aware of a spill but was simply too busy to clean it up. The store, quote, should have known about the spill. That's the third example. In legal terms, this is called constructive notice. It is where there is no evidence that the store created the condition or actually knew of the condition before the fall. However, by using circumstantial evidence, an argument can be made that if the store had acted reasonably, it would have known about the dangerous condition before the slip and fall occurred. Since number three, this example of constructive notice is a little more complicated than showing simply that the store actually created the condition or knew of the condition before the fall, let's spend a little more time on this. Have you noticed how most floors in these stores are vinyl or tile? They are hard. If someone falls, there's a good chance that they're going to get hurt. There's something else you probably notice about these floors. Yes, they get slippery very easily. And the stores know this as well. The responsible stores have very good policies and procedures to prevent accidents. They have written rules that require frequent sweeps or inspections throughout the store to look for hazardous conditions. If these store sweeps are done frequently and documented, juries often find in favor of the stores. However, just because there is a written policy does not mean the policy is actually followed. If a policy is not enforced, then there is no policy. We have found that some stores have policies and some don't. We have found that the stores that have good rules don't actually practice what they preach. Walking around a store a few times throughout a day is not sufficient. Similarly, we have often found stores that have a policy but no documentation that anyone is actually doing the sweeps. We've all seen those inspection sheets in bathrooms. Those sheets have the times and the names of the employees that perform the inspections. That is good documentation because it creates a record showing the times that inspections were done. However, many stores do not use sweep sheets. And even when they do, we have been able to prove that they have been doctored sometimes. For example, a sweep sheet may indicate an inspection was done at 10 a.m. However, when we obtain store surveillance videos, the videos do not show anyone doing an inspection at the time as stated on the sheets. That could be damning evidence against the store. Whether there are policies or not, there are other ways to argue that a store should have known about a dangerous condition. For example, if there are a lot of footprints or cart marks through a spill, that can be used to argue that the spill had not just occurred, but rather had been there for a long enough time for a lot of people to walk through it. And therefore, if the store had been doing its job, there would have been sufficient time for the store to know about the spill and clean it up before the slip and fall occurred. Another example that we have used in the past, or that we have seen in the past, if there were employees in the area when the slip and fall occurred, an argument can be made that if the employee was on the lookout, he or she should have known about the danger before the slip occurred. We have represented many people who slipped towards the front of the store in close proximity to a cashier. We have successfully argued that the cashier had a duty to watch the surroundings and failed to do so. The bottom line is that slip and fall cases are extremely fact intensive. The more evidence that a person can gather at the scene, such as photos of the spill, photos of the general area, as well as video, the better chance of finding negligence. If you ever fall in a store, if at all possible, remember that the more observations you make, the more helpful it will be for your attorney. I really hope that you found this video informative. If so, please click subscribe to my channel, hit like, and forward to your friends and family. I appreciate your time and sincerely hope that you are never injured in a slip and fall.